The European Union's General Data Protection Regulation, also known as GDPR, has been in effect since 2016, aiming to establish comprehensive legislation for data protection. However, there are two libertarian-minded objections to its approach that warrant discussion. The GDPR seeks to safeguard fundamental individual rights concerning the collection and processing of personal data. These rights include access, rectification, erasure, being forgotten, restriction of processing, data portability, objection, and protection against automated decisions. However, some argue that the notion of rights adopted by the GDPR is flawed. Libertarian reductionism posits that human rights are natural rights and that natural rights are property rights. According to the non-aggression principle, any aggression against property is deemed illegitimate. Consequently, certain rights protected by the GDPR appear to violate this principle. Take, for instance, the right to be forgotten. This provision empowers individuals to compel tech companies, such as search engine providers, to obscure search results about them. However, from a libertarian perspective, it becomes a contentious matter as it implies limiting the freedom of companies to use their hardware, software, and public information as they see fit. The GDPR assumes that data subjects own their personal data, but this notion is debatable. When personal data is generated through interactions with platforms like Google or interactions with other individuals, the ownership becomes complex. Moreover, displaying publicly available information in search results may not necessarily violate anyone's property rights. Beyond the flawed notion of rights, there are concerns about the practical effectiveness of the GDPR. While the GDPR recognizes privacy as a fundamental right, it often requires individuals to actively invoke this right for enforcement. This places a burden on individuals, as most people lack the time, resources, and means to engage with numerous private and public entities handling their data. Consequently, it grants controllers and processors significant leeway in data processing, particularly in automated decision-making. Moreover, the GDPR does little to address the potential abuse of power by governments. State regulation, as is often the case, can inadvertently favor big companies and governments over individual privacy concerns, thereby leaving individuals vulnerable. In conclusion, while the GDPR intends to strengthen data protection in theory, it faces criticism on two fronts. First, the notion of right adopted in the GDPR is seen as flawed, potentially violating the non-aggression principle and property rights. Second, the practical implementation of the GDPR puts the burden on individuals, making it ineffective in safeguarding privacy and failing to address state abuse. This legislation's unintended consequences may inadvertently favor powerful entities over the rights of individuals. Subscribe Libertarian Facts.